Thanks for joining us today. We are with our guests on the yes side for Proposition 24, which is about data privacy. We're going to give them 10 or 15 minutes as a time frame to give us a presentation, and then we'll ask some questions, and we'll try to keep it to 45 minutes or an hour. Appreciate y'all joining us. Why don't you take it away? Thanks so much.
Thank you. My name is Bob Hertzberger. I'm the Majority Leader of the California Senate. I want to start the presentation briefly to give both your editorial board and voters some explanation as to why this is on the ballot, and then turn it over to Mr. McTaggart to quickly outline the many improvements that we've made with respect to this measure over the existing law in California. This seems rather odd. What happened was the circumstances that kind of brought us here are somewhat odd. In 2018, or actually earlier, probably in 2016, Mr. McTaggart started this effort with respect to data privacy. He can give you a little bit of insights into the human side of what caused him to think about this issue. But he brought it to the legislature, brought it to the ballot for a 2018 vote. We in the legislature have adopted a new process that allows us to negotiate with ballot proponents after they've submitted their signatures to see if we can reach an agreement between the legislative branch. Reaching that agreement was rather unique because it resulted in a series of negotiations between Mr. McTaggart, our office, and a few others in order to get to an agreement that he would take the measure off the ballot. The way we drafted it, because we really wanted a full vetting in the legislature with full hearings, so we said, okay, we're going to delay the implementation for a year. That gives us an opportunity to really think this through, because this is such a complicated area of the law. When I was Speaker of the Assembly years ago, we dealt with privacy back 20 years ago, and it's always been very complicated, especially now as technology has overtaken so much rationality. And so the bottom line is that during that year, what ended up happening was that just dozens and dozens of bills were introduced by every industry under the sun to see themselves to be exempt. And it became clear to me from my legislative experience of many years that we just weren't going to get to a conclusion in the near term. There was a real need to move quickly because of what privacy was working on the one hand, and on the other hand, it just was clear that unlike other areas of the law, this was very different. So in conversations, we decided to go back to the ballot to make those kinds of improvements, because we felt that we could never make them in the legislature under the circumstances. And two things. One, the Attorney General's office, he made a public statement about his inability to really aggressively pursue privacy, which is one of the factors that caused us to go forward. And secondly, all of these different interests and industries all have different approaches to privacy, which made it impossible in my experience to be able to move forward. So we did really significant improvements over the law. And I want Mr. McTaggart to quickly outline those, because that's the principal question for the voters and for your editorial pages.
Great. Well, thank you so much, Senator. So yeah, just to reiterate, my group, Californians for Consumer Privacy, is the group that put the original ballot on in 2018, which results in the current California privacy law. And to just reemphasize what the senator was saying, in 2019, what I saw was the insurance industry come and try hard to get exempt from the privacy law. All vehicle manufacturers tried to get exempt. Google came back twice to try to exempt itself from behavioral advertising. And it struck me that with the power of the trillions of dollars on the other side, that unless we had some way of maintaining privacy in this state, it was going to be weakened over time. So what we did is we came up with this idea of having an initiative. The really important part of it is that it is basically just putting a floor under privacy. The initiative grants the legislature the right to make any change in the future with a simple majority. So it is not trying to freeze things in time. It is, however, saying that the only thing is you can't have any change that harms consumer privacy. That's the only thing. Okay, so let's talk about, while we're doing that, what was the basic principle? And the basic principle was, hey, Europe has the best privacy law in the world. in terms of most consumer protective, let's harmonize California's law with Europe. If Europe's the first world of privacy and the sort of authoritarian Russia, China is the third world of privacy right now, we're kind of stuck in the second world and we want to move up to the first world. If it's good enough for 500 million Europeans, it should be good enough for the 40 million Californians. So
the electronic
here's a list of the things that this initiative would do that the current privacy law does not do. So one is purpose limitation. So what we say is, hey, business, tell me what you're going to do with my information. And then, by the way, you can't do something else without telling me first and getting my permission. Storage limitation. Tell me how long you're going to keep my information and don't keep it any longer. Data minimization. If you told me you were going to do something with my information, then only collect enough information to do that one thing. So I'm on a weather app. That doesn't mean you should suck down all my contacts, which is the kind of stuff they do right now. This notion of chain of custody. Make sure, hey, business, if you're going to sell my information or share it, you can't send it to some other country or some other place where I have no rights. Anybody that you send it to has to have the same rights for me. So it's called the chain of custody. It all has to be protected. You got to have a requirement to have good security. You're going to collect my personal information. Make sure you keep it safe. A new right of correction. I should be able to go correct my information if you're keeping the wrong information about me. You said I've been bankrupt and I haven't, or you said I've, committed some crime and I didn't. Because right now, if Google says you did it, that's kind of truth in America. How do you correct that? We triple the fines for violations involving children's privacy. We've seen in the last couple of years that these companies just kind of flout this example. Google Play had, 5,000 apps that were in violation of children's privacy. One of my favorite parts of the new law, we create this new category of sensitive personal information. And we say this is so sensitive that you, consumers, should be able to say to businesses, you can't use this information. Right now, the current California law just says you have a right to stop the business selling the information. This says, hey, look, my religion, my race, my ethnicity, my health, my biometrics, my sexual orientation, these are things that are so personal. Hey, Uber, you need to know where I am, but you don't need to know my race or my sexual orientation. So I should be able to tell you, you can't use it. And then speaking of location, my favorite part of this one is my precise location. And what we do is, just like in Europe, we create a big circle around you. And ours is about 250 acres. And we say, you can't track me within that. Now, what does that do? That lets advertising continue. That lets business, continue to advertise to me. But it means you can't track whether I'm in the gym or I've been to the fast food restaurant 6 times this week. And wouldn't my insurance company like to know that? So it lets me blur my location unless it's actually necessary. Of course, Amazon does need to know where I am to deliver me the packages. It gets me the right to see all of my personal information. Right now in California law, you only have the last 12 months. Now this is all. We create a new agency to protect your information. And we fund it with $10 million a year. And that doesn't sound, for some people it's way too much money, and for some people it's not enough money. But the point is, it's more than double what is current funding. And that would, at the current level, equate to about 50 people in a privacy agency. And that's more than the country right now has in the FTC to protect the United States. There's 40 people in the division in the FTC that protects privacy for the country. So it would be a very robust enforcement, and much more than today. And more importantly, you wouldn't have the swings. If one AG decides to enforce it, another AG decides not to. This would be a sort of a professional agency that we keep on enforcing. There's the requirement for annual cybersecurity audits, annual risk assessments. Any excess funds go into a consumer privacy fund, interest on which goes to the general fund of the state. One of the reasons for doing that is we found when we did the study, some agencies that are protection agencies around the world, if they get to keep the funds, that creates the wrong incentive. So this just says, look, any excess funds go to the state of California. And then the most important thing, just I'll end with, is that it stops privacy from being weakened in the future. This is a new human right. And it's really important that for Californians, we have something that will stand up to the world's most powerful kind of wealthiest corporations that have ever existed. And I say this as a business person. I'm a through and through business person, but these businesses are so powerful that they need some regulation. It's time.
Mr. McTaggart, we have written for 4 years about the dangers of surveillance capitalism, and we certainly welcome your efforts along this line. However, it's striking that the Electronic Frontiers Foundation, a group that I've always thought was really smart and really helpful, depicts your measure as a mixed advance for privacy rights. It says Prop 24 would expand the power of a business to refuse a customer's request to delete his or her data. Specifically, a business could refuse when it believes retention would help to ensure security and integrity. That's kind of open-ended. It kind of means they don't have to do anything. Moreover, the initiative would diminish a business's duty to transmit a commuter's deletion request to downstream entities who got that consumer's data from the businesses. So I just am kind of baffled by this. If the leading organization in the state on privacy says that your measure, in fact, weakens some existing protections, how can that be?
Can I answer that question initially? I was going to, and then you can go on, Alistair. Look, you know, the author of surveillance capitalism, the godmother of surveillance capitalism, is part of our advisory committee and strongly endorses this. She is extraordinary and she is brilliant and she has scrubbed this and she knows what it means. So I just want to say, when you talk about surveillance capitalism, the inventor of the word is part of our Yes on 24 team and dramatically and pushes hard for this. She's participated a lot with us and the like. Two, I'm telling you internally what happens in politics from my own view. I know the people at the EFF. I know who the lobbyists are and what they're doing. And there was a series of coalitional folks that came to us with a list of 41 ideas of they wanted to do, and we took 27 of them. The big issue that informs their thinking, and often what happens, just like you see in anybody in the media business or whatever, someone comes up with an argument, it's all about the private right of action. They want the private right of action. We did not put the private right of action in this measure. That issue, and also with respect to the idea of like Turn has, what is it called, intervener fees and the like. These are the real motivations. Obviously, people come up with reasons. So I don't want to tell you otherwise. I know the folks, who they were, what they did, and what they were pushing for. So I'm just telling you, the folks on that side, Andrew Yang, you look at Tristan Harris.
Senator, let me just ask, maybe I'll just answer his question, Senator.
Yeah.
Okay, so with respect to deletion, actually, I strongly disagree with this assertion we made a week ago. We made the deletion exception, deletion section 105 much stronger. So let me explain how. One, in current law, there's no ability when I say to business A, delete my information, they just have to delete my information. In the new law, if this passes, when I say to business A, delete my information, they have to be in a position to tell everybody that they have shared the information with contractually to also delete that. Now think about what that requirement does to when I'm sharing information. Now I have to be in a position where I can require the businesses downstream also to delete it. That's the first thing. The second thing is what these people are focused on in that particular section is a misreading of what we've done. In the existing law, one of the exceptions for deletion, where the business doesn't have to delete it if I tell them to delete it, is based on a fraud exemption. So for example, if they've identified me as a fraudster, and I'm living in Moldova or something, and I'm a fraudster, and I say, you know, delete my information. Actually, I have to be in California. I'm sorry, that's a bad example. But if I say delete my information, they don't have to delete my information if they think I'm a fraudster, which makes some sense because I keep on coming back to try to, and if I can release my information, that's not a great situation. In the new law, the part of the problem is we have a new defined term. Instead of every place having the sort of like the 2-line definition, we have a new defined term of security and integrity. And there are 3 components to that. One is what's in the existing law. 2, we do add the wording that's in GDPR, which is the ability of a system to resist an attack. That's the second thing. And 3, we also include a safety thing, a physical safety thing. So for example, if Uber has identified me as someone who's assaulted a driver, or Airbnb has identified me as someone who trashed a home, then also they can use that, which is not an existing law, as a way to say, no, we're not going to delete your information. But there's absolutely nothing in the deletion section 105 that is anything, I think, other than stronger in terms of more consumer friendly and more privacy friendly than existing law.
Let me just jump in, because I don't think either of you actually answered the question, which is why didn't you do more to get EFF on board? They obviously have a lot of credibility on this issue specifically, and their word carries a lot of weight. So why not do more so that they aren't on the other side of the playing field here?
Well, I've answered the question, because the bottom line is that we took almost everything of what they wanted, but the big issue was the one thing that they would not come on board with was unless we had the private right of action, and we didn't agree with that. And so that's the reason. I mean, the reality is when you're sitting down and trying to deal with something as this complex, you know, at the end of the day, you're trying to reach some conclusion that works, and they would not deal with it. They just said, this is the way it is, and this is what we want. And so, you know, what they asked for, we weren't willing to do. It's that simple. And that was that's the big issue.
Okay, I appreciate that. I appreciate that. So then my question becomes, why not work this out in Sacramento? We met with Proposition 22 yesterday, and that ballot measure seems like one that could and should have been handled in Sacramento. It's got so much nuance to it. There's so many issues that aren't addressed in this ballot measure. And the same to you. It seems like this is such a complicated issue. You have people like, you know, not just the EFF, but the ACLU and other groups on the other side of this. Why not just deal with this in Sacramento? Why take this to the ballot?
Boy, that is a great question, because I spent over a year trying to reach an agreement on Prop 22. And Prop 22 was much less complicated in the sense of labor on AB 5 versus the gig economy and what that looked like. It was personalities. It was individuals. I could spend hours and tell you what really happened behind the scenes. And we were working up till the late last minute, and it's just had nothing to do with that. This issue is quite different. And that's what I tried to explain in the beginning. Unlike anything I've ever dealt with, whether it's the doctors versus the lawyers, every other issue, I've done dozens of ballot measures. I've done dozens of laws as speaker and way back when and the like. This is different because different companies have different approaches to monetization. So you have Google against Amazon, which is against Apple, which is against AT&T, and they're all just, I'm telling you, they scramble for cover me and do me my thing, and you legislators over here do this. And that's what happened, what Alistair was telling you. And when I looked at the framework, and I've been involved with, don't forget, when I was speaker, we did privacy with Jackie Spear, if you remember, 20 years ago. I hired a fellow who's a former Supreme Court clerk, spent an entire year working on this issue. It is the most complicated thing. And then the other thing that made it so difficult was in the 2018 law that we passed, we gave the authority to the Attorney General to be able to enforce this. And Alistair will give you the specifics on the date, but he's made a public statement saying, I can't do that. So here you have the Attorney General saying no. You have this extraordinarily fast moving area that's critical to California publicly. You have on a national level people criticizing us because they found the holes in the process. And so, you know, it became a difficult choice, but the right choice, because we spent hundreds of hours. We had meetings with the Attorney General's office, in my office. And obviously, look, I'm a legislator. I believe in the process. But I'm just telling you my best advice based upon my extensive multi-decade experience was this, you know, I'm doing bail, okay? And that was a murderous one. First time since 1981. But this one, this was the only solution in my best judgment after talking to everybody and, you know, listening to all the people coming in my office for a year and nothing happening except the kinds of things that Mr. McTaggart mentioned.
Can I just add one thing? One, just to get back to the previous comment, you know, EFF doesn't oppose us. They're just neutral. That's one thing. And then in terms of the Sacramento, I kind of feel like we are. This law leaves it in Sacramento. Any change Sacramento wants to make is up. It's fine. It's just that it can't hurt consumer privacy. You got to keep on remembering that this doesn't take away any of the legislature's rights. It's just putting a floor under privacy.
Let me ask you about that, because some of the criticism is that any future privacy laws are, as an op-ed writer in our paper said, null and void if they conflict with Proposition 24.
So we spent a bunch of time making sure that the purpose and intent section, what it basically says is, you know, you can amend anything that's it's consistent with the purpose and intent with a simple majority of the legislature. The opposition has raised this canard that like, oh, well, this is going to give business some right to veto it. So we went out and got a pro bono, independent third party to look at it. And David Carrillo is the founding executive director of the California Constitution Center at Berkeley Law. He reviewed it you can read a long 3,500 word article, basically confirming that, not basically, completely confirming that that our approach is 100% correct, that any change the legislature wants to make that doesn't harm consumer privacy is fine. Just think of this as one way. We're just trying to say it's small little privacy advocates over here and the world's most powerful corporations over here. They will win. We all know about money in politics. They will win unless we have something to protect us. And if you're worried about this, you should talk to Jamie Court from Consumer Watchdog, because he's in the same situation with Prop 103 from 1988. And he is an expert in this because he's been through this particular thing, and he will confirm for you that the jurisprudence in California is super clear. This basically just creates a floor, but allows for any amendment going forward that the legislature in its wisdom thinks it's good for consumer privacy.
And can I just tell you, the thing that got my attention back in 2018 that Mr. McTaggart had in his original initiative was he required a 70% approval by the legislature for any changes. And that to me violated the principle. The reason, and probably the thing that we spent the most amount of time on in all the various discussions, was making sure, there were a lot of groups that didn't want it, that making sure that this was consumer facing and we set the floor. That was foundational. In terms of the discussion at 50% plus one to give the legislature the power. Otherwise, I wouldn't have participated.
One of the concerns I had about this in doing research for this particular meeting was looking at your website, and the way it is set up, it would indicate to the layman that some of the people supporting this, some of the organizations supporting this, are not yet, in fact, supporting this. The website shows just by its layout that the San Jose Mercury News and the San Francisco Chronicle are yes on 24 because of the logo slapped on what are actually news stories. So I'm wondering, I know this is it's your job to convince the public to vote for this, but do you think that is a little disingenuous to give that implication that their news coverage of these events are in fact endorsements of these events this initiative, when in fact they are not endorsing this?
Well, I think we got very positive articles so I think the Dustin Gardner article in the Chronicle was very positive. So we put it up there. I don't think we say that it's an editorial endorsement of it. I think in terms of endorsements, when you think about it, just kind of going back to this ability to amend, we have over almost 30% of the Senate supporting us. We have assembly members.
Exactly. But my point is the website shows a yes on this measure over 2 stories about the measure from news outlets that have not endorsed it.
Well, I'll take a look at that, but I think that what we have done is shown the actual stories with the logo of the paper, and we have a link to the actual article. So I think that's there's no intent to do anything other than show people, to link them to the articles that the news organizations themselves have published.
It's hard to believe you don't think that's misleading.
Well, I will go look at this. I'm almost certain we don't say that there's editorial support from these news groups. I'm sure we say that the articles are from the journalistic publication.
Let's just look at it. Let's just look at it. I haven't seen it. I don't look at the website, honestly, but let's just look at it. If it's misleading, we'll fix it. It's not a question. That's not the purpose. We're not trying to mislead anybody. I just trying to post a positive article. But I don't look at the website, to be honest with you, but if you're right, we'll fix it. It's a fair call, fair question.
I don't know if we gave Robin the opportunity to speak if she was planning to, but we didn't give her that opportunity. So I don't know if this is the time for her to say something that she wanted to say.
Oh, thank you, Laura. The only thing as campaign manager that I would want to reemphasize is just that we do have an astonishing number of really widely respected endorsers and privacy experts. So the senator mentioned Shoshana Zuboff. She is the author of Surveillance Capitalism, and she is also in that Netflix docudrama, The Social Dilemma. We've got Paul Romer. He's a Nobel Prize winning economist. We've got Chris Hufnagel, professor of law at Berkeley. We've got Roger McNamee, who wrote the op-ed for your paper, also in the movie. Johnny Ryan, he is from Ireland and internationally renowned. Ashkan Sultani, who worked at the FTC as their chief technologist. Mark Rotenberg, who worked and ran Epic for 20 years. So the folks we do have on our side are true privacy experts, nationally and internationally. And when you're talking about, you know, the legislature, we have phenomenal support from the legislature as well. So we've got Senator Ben Allen, Senator Jim Bell, Senator Bill Dodd, Senator Lena Gonzalez, Connie Latham, Bill Bonning, Nancy Skinner, of course, you know, Senator Hertzberg here, Scott Wiener, Bob Wykowski. It goes on and on. So clearly folks in the legislature thought we needed to do this on the ballot as well. And that was because it was so vulnerable. The CCPA was so vulnerable sitting in the legislature. And I would love to follow up and send you guys some more materials. There was an interesting article in Wired this morning that I think addressed some of the concerns that you are bringing up right now and why the CCPA was in fact weak, and that this initiative strengthens it. So I thought that was a great piece. Yeah, I think there's a lot of information on our side, and we're just trying to correct misinformation that's coming our way. But I think probably the biggest misconception is that this would somehow weaken privacy. I'm not sure why Alistair McTaggart would have spent all of the time and resources he did 4 years ago, because I've been working with him for 4 years, putting the CCPA and then doing a legislative deal, and then following up when Senator Hertzberg said, you know what, we need to go back to the ballot, and putting it on the ballot if this would in any way weaken it. You know, I wouldn't be working on it, and certainly Alistair wouldn't have spent all of his time, money, and resources as a person who has absolutely nothing to gain from any of this. He's somebody who has been interested in this issue and taken the bull by the horns and has been truly a citizen activist. So that's where I would start. Thank you, Laura.
You know who I worry about? I worry about the people like my mother. She doesn't live in California, who have a flip phone, people who don't read all of these agreements. You and I both know that you've been in a hurry to download an app or to do something, and you're not going to read 3 pages of agreement. I'm sorry. If everybody here says they do, I don't believe it. I worry for the people that don't understand both sides of the issue, and you know, it could be younger people, someone who's, you know, if my children are on my phone plan, I don't know. But what would you say in 20 seconds to somebody that really doesn't understand this issue, because it's so complicated?
That's
and then
why
you can add layers to it and say that there's people that are English is not their first language, and they're going to vote on these issues. So what would you say in 20 seconds to these people that do not understand these issues?
Laura, this is exactly why I'm doing this, because I wanted you to never have to read another one of those. The same way you don't have to be a flight expert when you get on a plane, you just know it's going to be safe. I wanted you never to have to read another privacy policy, because I want the law to protect you and your mother who doesn't read those things.
My question is,
In other words, explain how that works. Explain how it works. You just hit a button and all the other servers have to respect it and says, don't share my information. It's one stop.
I mean,
Explain that.
You only gave me 20 seconds, but if you want the longer version, it's that what's going to happen over time is that the law is set up to protect you and your privacy, so that over time, it's not going to happen overnight, but over time, what's going to happen is we're going to look back on this age when these big companies were able to track you across every site you visited, across all your devices, from your Fitbit to your car to your desktop to your phone to your partner's one, and they were able to harvest all this data and use it all free, no restrictions. We're going to look back on that time and say, oh my God, that's crazy. There used to exist that kind of a situation, and over time we're going to put restrictions on it to put you in charge of your own information, so you know that it's that you're in charge. I can't say it more clearly that you've got to get away from the system where it's where these companies are exploiting all of us by tracking all of us all the time, 24/7, everything we do. They know us better than we know ourselves.
There are some people that might say it's a choice. It's a choice to have that device. It's a choice to have, you know. There's people that might say then don't have a phone, don't have a
Yeah.
smartphone.
And what I would say to that is you can't exist in today's world as a normal human being without that. If you have a job, your boss is going to text you at some point. You're going to need to know if schools closed that day or open that day. You need to check the air quality index. You need to, go look for a job. Yes, you could live on a farm somewhere out in the middle of the country, but if we're going to live in today's world, it's very hard to take opportunity, to maximize your ability to exist in today's world without using this technology. It's just embedded in everything we do.
And Alistair, I do want to jump in there for just to directly address Laura's question. I do think the Wired article that came out today, I'm going to forward it to you, explains exactly why you're not going to have to, read 50 million privacy policies, which is what you actually do have to do under the CCPA right now, and how Prop 24 essentially eliminates that step. But I will tell you, as a mom, I got a kid in the other room on Google Classroom right now, and I don't know what Google Classroom is collecting about him. In 3rd grade, he's taking a statewide exam right now. And it's very concerning to me as a mom that he doesn't have any rights right now under those laws, under the current law. And he doesn't know what he's getting himself into when he's on Google Classroom, and all of every sentence that he's written is tracked, every math problem, everything. And so putting these safety bubbles around our privacy is important, not just for those of us who do understand it, but even more so for those like my kid who don't.
How does this address enforcement? We've all heard about the do not call list, and we put our names on the do not call list, and it never worked. People keep calling. So what is the enforcement built into this, and how does it affect a tiny business like a pizza shop that collects your phone number, or a small industry, a small company that might collect something of yours for that very purpose, your address and your phone number, because you get pizzas delivered a lot, that sort of thing?
So 2 things. The enforcement, we think, becomes much more robust. As I said earlier, you got more resources being directed towards it. And so we think, there was an Office of Privacy Protection in California, which Governor Brown eliminated. This stops it being eliminated, stops annual appropriations fights. And this also allows all the counties and the big city attorneys to enforce it as well. Because right now in CCPA, it's exclusive enforcement to the AG. This would now allow for enforcement across the state by the 50 counties and the 4 big cities. In terms of the small business, one of the things we think is great about this law is we improve it for consumers dramatically, and we also improve the workability. So in the existing law, the definition of business could potentially sweep in a lot of small businesses. Actually, doesn't potentially, it sweeps in a lot of small businesses who are not the problem. The problem is not the pizza shop, to your point. Now, I will say one thing. Oftentimes the pizza shops sell your phone numbers because they actually can link your address to your cell phone. If they're doing that, that's selling your data. But if they're not doing that, and they're just a local pizza shop that just knows where you live and delivers it, we don't want to cover them. And so this law, much more succinctly than the CCPA, ties whether you're a business covered by the law to, are you buying or selling personal information? If you're not buying or selling personal information, we don't really want to, why should we bother the little flower company or a little t-shirt store? And so that's one of the reasons that we think this law is much better for small business, because we cover far fewer of the small businesses that are not the problem.
Will you talk about what this looks like from the consumer point of view? Because currently we go to a website, we're asked, whether or not they can collect cookies. It's kind of such a pain and such a rabbit hole to go down to revoke that right, that most of us just say, yeah, sure, let's get on with it. So, under your proposition, what will that look like for web users?
It's a great question. And it's part of one of the problems of some of these privacy laws in general. And in Europe, the GDPR, that's their law there, also has this problem. And people actually have a term for it. It's called click fatigue. You just click it and you stop paying attention. This law includes a new provision, and we're trying to set up a carrot and stick for businesses where if they don't put the do not sell button, then you have the right to go there with your do not sell signal enabled, and they can't retaliate. They can't charge you more. They can't do anything. over time, it would be great to get to a situation where you were able to put the do not sell signal on your phone in your browser. Because just stepping back, the way it's going to work over time, and there's a new announcement today from a group of technologists about this do not track kind of reinvention. There was a do not track idea. It didn't get traction 10 years ago. Now the law mandates it. And so if you have to do something every time you get to a website and hunt around for a do not sell button, which they're hiding, it's not going to work. The only way it works is if it's easy for you and you don't have to think about it. It's a set it and forget it model. And the way you're going to do that is you're going to set it once in your browser. I don't want my information sold. I don't want my personal information, my sensitive personal information used. You'll set it once on your phone. Hey, I'm just a global device setting. Or you'll hire an app the same way we all have antivirus software. And if you do that, so it's easy, this thing will work. If it's hard, the businesses will win. It's got to be easy. And so right now, Christy, we're in this kind of interim phase where they're trying to make it difficult. I mean, I'm pretty involved in this. I'll go to the do not sell button and I look at it, I'm like, which way am I supposed to click this? I don't really understand. And then you read the wording and you still can't understand it. They're actively fighting to try to maintain control of all this information, which is their raw material. It makes sense. I understand why they're doing it. Our goal is to give you rights and to make it easy for you so it's effective.
Yeah.
Can I follow up on that for a point of clarification? Because the op-ed that we had talked about how the privacy poll tax is not in this, and that if you opt out, companies can charge you more. Did you just say that that couldn't happen?
So the current law allows, if you opt out, the business to charge you a fee.
Correct.
And the future law does that too. And I just want to talk about that for a second. Thanks for asking that question, because there's been so much misinformation. The reality is, and you as a newspaper business, you'll understand this better than anybody. The reason that provision is in the current law and in the future law, if it gets enacted, is that if a consumer goes to a business and wants to get, if a consumer comes to a newspaper and says, I have my ad blocker enabled and I want to see all your content, how are you supposed to pay for yourselves? And if you don't have a provision that allows for differential response by the business to the consumer who shows up, because I could come up to your paper with an ad blocker and say, I don't want any of my information to be sold, because essentially when I'm seeing an ad, the newspaper is actually selling my information. They're sharing that I'm there on the site and please show this guy an ad. If you don't have this provision, we'd have put every newspaper out of business. So you have to have some kind of provision that allows businesses to take a reasonable step in response to a consumer who shows up and says, I don't want to have my information sold. Another good example is a music streaming service. You go to Pandora, some people choose to listen to ads, some people choose to pay a subscription fee. And because when the ad is happening, that's when the personal information is being transferred. Now, over time, can we get to a world where all the ads are contextual, not behavioral, so that they're only related to the article you're seeing and is much more privacy protective? Maybe, I think so, I hope so. But it's like saying, should we all have electrical vehicles? Yes, at some point in the future, that's the right way to do it. Should we stop selling gasoline today? That would be a real hard thing to do. So it's a transition. The reason that this provision is in the existing law, we don't change it in the new law, is because you do need some, we call it preserve the free press. You would actually put so many papers out of business if you said to the newspapers, by the way, you have to offer all of your content for free to anybody who shows up with an ad blocker. It just wouldn't work.
Are you saying that, so you're saying you go to these sites and you don't have to read the policy anymore? I'm someone who does read the policy on every app that I go and get. Wow. Sorry, Laura. There's one of us.
Not me.
But to me, it sounds like you're taking, like, would that still be an option? Because to me, I want that, and that's how I decide. I know not everyone looks at that, but I don't want that to be taken away because I like to know the specifics.
You must be one of the 4 people in America who do. That's great. I've never heard anybody say that before. That's great.
Well, Abby, no, of course, I'm not saying that I don't want you to have the ability to read what's there. The privacy policies will still be there. They'll still be required. My only point was to Laura about her mother. I want her mother not to have to think about it and to know the same way, this is just like any consumer regulation. If you think about car safety, you know, in the 50s, the car manufacturers fought it, but now we have way safer cars, and think about trying to sell a car without airbags or anti-lock brakes. Now, I'm not an anti-lock brake expert. I'm not a airbag expert, but I know that they're there, and I assume someone has checked out that they're safe. Sometimes they're not, but in general they are. I kind of want the same construct for privacy. Sure, you can get involved and read the policies, but in general, there are certain things that I think should be in all of our kind of, this is a new right. This new technology didn't exist before Jobs invented the iPhone. And now we are all giving of ourselves all day, every day. We're exposing our most personal information, and we should have some control over that. And so I'm absolutely not saying that you shouldn't be able to read the privacy policy. I'm just saying that for people, without spending a lot of time, we should be able to know that our privacy is being respected and that we have control over our data.
Well, so I feel like I make like a calculated risk with everything that I do. Some things I say, okay, I'll put up with this because this app is worth it to me, or this, you know, browsing experience is worth it to me. So how does that work? You know, if you're not going to have the button on each site and you have some sort of blanket, because that's kind of a problem too. When you tell everyone to stop reading cookies, then you're in a battle against everything in the other direction. Well,
I think a good example is if you want to take a look at some of the deceptive practices. So there was a company called Copley Advertising. There was a 2017 settlement in Massachusetts. They were geofencing reproductive centers. And when women were in there, they were showing them right to life ads. So, you know, most people don't think, okay, I'm on the weather app and I'm just checking the weather and I'm sitting here at a very vulnerable time in my life. Wow, I just got this right to life app, that live chat offer. That feels pretty invasive. Or speaking of weather apps, the LA city attorney right now is suing the Weather Channel because of their practice of you check the weather and you see an ad. Okay, you're sort of expecting to see that. What you don't expect is that your actual where you're standing, your location is being sold in that moment. And so I think you can make a calculated risk, but and if you want to do that, that's of course up to you. But I think most people feel like they'd like to have some control over the data, and there's this gap between the expectation and what's actually happening. That gap we're trying to eliminate.
Esther, I think directly to her question, maybe you could talk a little bit about sort of how we protect the choice of consumers. And in fact, what the opposition is saying is quite the opposite. They don't want consumers to have that choice that Abby is talking about.
Sure. I think this is why Andrew Yang supports this. We believe that your data should be yours. If you want to enter into a relationship with Pandora, where you say, look, I'm going to get the free music. And I don't want to have to pay. And I'll listen to a couple of ads, which essentially is my data being sold. I actually do that with Pandora. I listen to that. I have the free service. I'm like, great. I listen to a couple of ads, no big deal. I'd like to have that freedom. The ACLU does great work and they do some really good work, but they're also very kind of axiomatic about some stuff. And they think that choice shouldn't exist because they think everybody should have the right at all times to not have to have any of their information sold for any, have not to pay for anything. And the problem is that takes away consumer choice. So we think that you should be able to I'm going to have the newspaper where I'm going to pay a subscription, or I'm going to have the newspaper where I'm going to see ads. That's up to the consumer.
You brought up the GDPR, which required a lot of online companies to change the way they do things. And this being a California measure, I'm wondering, can you talk a little about the nuts and bolts? If I'm a developer in one of the 49 states that don't have this strongest measure in the union, I guess that means they have to comply with this as well if they want consumers in California to view their sites, and that goes the same for international companies.
It's a great question. The construct is we give rights to consumers in California. So it doesn't matter whether your company's in Tokyo or London. If you're offering the business in California, which you're going to do because we're the 5th largest economy in the world, you have to offer services. You have to comply with the law here. But what's interesting, what happened, and I'm convinced will happen, is so Microsoft and Apple both didn't have to. They extended the consumer rights under CCPA to the entire country. Other companies did as well. It's untenable if you're a consumer company to say to the person in Texas, oh, by the way, sorry, we're not going to give you the same rights as the guy in Sacramento. or your brother-in-law or your cousin there. I just think that over time, we, California, lead the way. And so the businesses will rise to our level just because they kind of have to, I think. So I think that's what happens.
Let me ask you a broad question. You know, we talked about CCPA and that being in place for not very long, right? There's really no data to show the effect of that law, the changes in that law, reaction to that law. Why not wait and get that data before moving? I know the senator talked about this rush that we're all feeling, but why are we feeling a rush? Really, it seems like an artificial rush to me, where I'm sitting.
My answer there is, one, this law won't go into effect if it passes until January 1st, 2023. But two, if the other side was going to say, okay, we'll stop and we won't do anything, then okay, that might be a discussion. But the reality is, what I saw is, you know, the thing passed in 2018. I was like, oh, great, you know, this is wonderful. And then January last year hit me like a ton of bricks. And I realized, oh, these people just saw me coming like a rube, because they just introduced, there were 7 bills introduced that would have just massively gutted CCPA. And so you realize that the businesses will just keep on coming because this money, this is so valuable to them, and they so don't want any restrictions on their raw material. So that's where, you know, you had, again, just kind of took my breath away. We're just going to have a bill. By the way, these weren't bills this got out of committee. This got out of the assembly. This bill to remove all insurance companies from the law, to remove all vehicle data from the law. Cars are computers on wheels. They know how much you weigh. They know where you eat lunch. This is where the data is for car companies now, where the value is. You know, at the end of session in August, Google had this 7-word fix, just 7 words. And Senator Hershberg called me up and said, hey, what do you think of this? And you read it. And I'm like, this is really good lawyering. If you change these 7 words, all restrictions on behavioral advertising would be removed. That's the tracking you from device to device across all the websites you're on.
Yeah, and can I just add, yeah, and there's just literally millions of dollars in lobbying fees that are spent. I'm part of the National Speakers Conference for my old job, and also with the Majority Leaders Conference at the State Legislative Leaders Foundation, and we're looking at this on a national level. Both Alistair and I went back to Washington, and it's one of these areas where you have these trillion-dollar companies and this technology moving at a breakneck speed, and you know, the whole game is to muck it up. It's so different than anything I've ever had to deal with over the years, this issue of privacy and how it works politically, how the interests change and the like, and just the need to get some framework and stability around it that was forward facing for consumer privacy, but kind of stop the noise. And that's kind of the hope is. And obviously, if people want to introduce legislation going forward, they can in furtherance of privacy. But I think that to try to create a frame around it, particularly when the Attorney General, after we gave the Attorney General the authority, basically says, I can't enforce this, I can't make it happen. So it was an illusory play. Except for Illinois and state of Washington, there's not much going on. A lot of noise gets introduced. Millions of dollars are being spent a month in Washington for everybody arguing their play. There has to be some framework. And we think that I particularly am of the view, historically, I can give you other examples of where we've done things in California that has helped inform the national debate. So that's the reason. There's sometimes public policy issues take time and you incrementally deal with them, and certain public policy issues change. And in my judgment, after all these years of experience, this is one of those things that we just needed to create some framework around and give it a shot. Obviously, that's why I started this conversation about the issue about how odd this is. Because here I am, we spent hundreds and hundreds of hours with Mr. McTaggart telling him, take this measure off the ballot. Then I come back and I'm spending hundreds and hundreds of hours with him and other experts that he's hired saying, put something on the ballot. It's obviously a fair question, but it's an honest approach to a very significant problem. And the one thing I want to say that the other side always talks about is how many pages this thing is. Well, first of all, what happens is, and it's been a frustration because we tried to do this, you have to reprint the entire 2018 law, the CCPA, and then show the changes to it. You can't just put on the ballot these X number, 10 pages or 12 pages of new material. You have to put the whole thing on the ballot. So that's the reason why it's so long, because it incorporates, and even some of the questions that are being raised by opposition is exactly the same language that was in the original CCPA in 2018. It's like you want to pull your hair out. Because and the last thing, and I know this is, I'm just telling you, as somebody who lives in the belly of the beast, who's inspired deeply by the big picture issue of public policy, and despite all my years, I've never lost the light at the end of the tunnel, is that it's always these groups. Everybody can find something to beat you up on and play the game, but these are big issues, and it's an important thing to do. And it was a big risk for Mr. McTaggart, and it's a big risk to make this thing. But given the circumstances and the best analysis, no question, this was by orders of magnitude the right thing to do. And in my judgment, the most important thing on the ballot, because it's going to inform privacy when we pass to, fingers crossed, affect the entire country in a positive way.
To your point about the length and the complexity, the subtext of much of this conversation was people don't read privacy drop-down menus on their phone. What percentage of voters are going to read this ballot? Two? Less?
No, small percentage, no question about it. This and every other initiative, and I would venture to guess on Prop 15 and Prop 22 and Prop everything else, they're not being read. I've polled these things and looked at them. There's no question. It's one of the challenges. I had the Speaker's Commission of an Initiative Reform in 2000, and we looked at this very deeply. But the public has this split opinion. On the one hand, they say, you as a legislature should solve this problem. Don't waste my time. But on the other hand, they say by a vast majority, I want to reserve the power to the people against the legislature, against the government. And it is something that we have faced, and we have seen initiatives on the ballot much longer. Mr. McTaggart talked about Prop 103. That was the year where there was 6 insurance initiatives, competing initiatives of hundreds and hundreds of pages. This is a larger dynamic that exists in the context of initiative reform, and what does that look like? But we've tried to do things where we previewed them and have the Supreme Court review and all these various issues and face constitutional constructs and the like. So it is a challenge, but it is the dynamic we find ourselves in with respect to the public opinion and their tremendous cherishing of the initiative process.
Is there concern on your part that even if this were to pass, when you go back to the enforcement piece, what would that look like? Like, would somebody that broke this this law end up, would this all be tangled up in courts for years and years and years, and it really wouldn't matter anyway? I mean, what would the enforcement look like?
Well, I think that the way it's going to work is we're going to create, just like we do with the FCC or the FEC or these other things, we're going to create this agency, and the agency will issue fines, and it will create a body of law around it. We create flexibility for that and try to handle this at an agency level. You don't want a situation where you have a gotcha game and everything results in litigation in a courtroom. The two theories behind this is, one, hopefully if there becomes a body of law around privacy, that there's less and less legislation introduced and more kind of acceptance like we have with the Fair Political Practices Commission or other entities and the like, that creates a body of law. And then if someone really makes a mistake and really does something bad, the Attorney General has jurisdiction to do anything they want, so they can go after anybody they want, but they can cherry pick the cases of the big ones. The day-to-day kind of stuff is dealt by the agency, and where there's holes, the legislature can fix it. So it's a really elegant solution between the executive, the legislative, the Attorney General's office, to try to create a body of law that works for people, that really has enforcement. Because unless you have a private right of action, which we did not want to do, either in the earlier one and this one, where private lawyers can go out and sue and play the gotcha game, in my judgment, we created an agency. General can still go after the big stuff and get the big fine. So it's a really intelligent balance in my sense. And Mr. McTaggart talked about the idea of not incentivizing the agency to just go after stuff that really does the enforcement element in the good way.
Let me, we've got about 5 minutes left. I just have a couple more questions, pretty big ones. In Prop 22, we're seeing Uber, Lyft, DoorDash spending $80 million in a ballot measure. We've spent part of this conversation talking about the big bad tech companies who are spending this much against your measure. Isn't that a sign that they don't have a huge problem with it? That it's not as restrictive as it should be?
Yeah, fair question, fair call. Let me tell you what it is. Last time around, when McTaggart had his measure and they went out to spend it, nobody wanted to look like they were bad actors They didn't want to look that way. So one of the problems was they could have put up $50 million last time around when Mr. McTaggart had his measure on in 2018. We met with them. I had talked to the Chamber of Commerce, Alan Zerenberg, who I love. And he's basically saying, hey, look, you guys are idiots. If you want to fight this, fight this. But they're in a situation where when they hated his last one, and they didn't want to put up the money because they're worried about a PR image and the like. And I was told that their answer, they were going to fight it last time, is they were going to fight it on law enforcement and saying, oh, this is bad for law enforcement, or some theory, because they didn't want to look like they were fighting privacy because it was. And we think that it's the same thing now. There were some people that were talking about opposing this. I just had a series of conversations the last couple of days with the chamber, and nobody wants to get out there. They want somebody else to front it off and look good, but they're too scared politically to fight it. And they know that this is a freight train on consumer privacy that they need to do. That's my political judgment. If you want to add anything, Robin, or Alistair's not.
I do, Matthew. I would just say that it's not for.
Huh?
It's not for lack of trying. The opposition, we circulated a memo that they sent around soliciting money from big tech companies, asking them to start at a 50 grand gimme. Like that's where they started. They were trying to solicit money. You'll see now, if you look at the Secretary of State's website, that they are $108,000 in debt. So perhaps technology companies don't want to give money to a campaign that is breaking the law, not disclosing where their payments are going, and not for lack of trying, they solicited funds from big tech.
Just to answer Matthew's question, I just think that for me, the answer is the cost would be extraordinary. We're seeing what Uber and Lyft are spending to go from whatever 33 to try to get to 50. So you're going to spend a couple $100 million. It's terrible for their brand at a time that they're very vulnerable to antitrust. So their bigger fish to fry is, let's stop being broken up in the 50 states. And this is what Senator Hertzberg told, a year ago, sort of said, you're going to have them vulnerable where they're not going to be able to spend the money from a consumer acceptance point of view. So I think that's really what's going on is if you're fighting 50 states and you're fighting this PR war in Washington, you've already looked terrible. And now you're going to spend $100 and $200 million in your home state against privacy. It just doesn't look good.
And then let me just jump to my last question in the interest of time, Senator. And I guess for you, Alistair, I mean, one of the things this does is create another government agency to oversee this. Government agencies don't have great track records. Why does California need another government agency to oversee what's a super complex issue? All I got to do is think back to when Congress was talking about the technology, and you had a bunch of people who had no business having that conversation, respectfully to the congressional leaders who were in that conversation.
Matthew, it's a fabulous question, and my answer is sometimes in life there's no perfect solution. Should we have no enforcement? We've got to have some enforcement. What we saw with the Attorney General is, look, I understand he's got huge fish to fry himself. He's trying to stop people getting deported. So he also doesn't have as much resources as he would like. You have the risk of political capture, or you have the risk of agency capture. Could a politician who wants to run for governor one time, could he or she perhaps go light on the tech firms? That you can envision that happening. We tried to set it up where it's as independent as possible. There are 5 commissioners appointed by the Senate, by the AG, by the Assembly, by the governor. And we say that if you've been in a matter, you can't work for 2 years on a matter before that commission. So we're really trying to separate church and state. So it's not a revolving door where you go there to get wealthy. But at the end of the day, you do need a cop. And I agree with you in general that I'm not a big fan of more government just for the sake of more government. And yet, if there's a better answer, by the way, the legislature can make that decision.
Okay, thank you for that. We did just hit 10 o'clock. Any last questions from board members? I think we covered the waterfront here.
I do have one really quick question, Alistair, if you could just answer in 15 seconds for us. I think both the senator and Robin alluded to why they're passionate about this, but why are you so passionate about this issue?
If we don't get privacy right, democracy will not survive. Privacy is the wrong word. It's not privacy. This is power. This is how these giant companies are fueled. This is what they exist. This is why Google's $1 trillion company. This is why Facebook's almost $1 trillion company. And right now, if I know everything about you, Laura, I have an extraordinary amount of power to direct you without you knowing it. Right now, that power is in the hands of 1 or 2 people. That does not end well in a democracy. It's fine right now. Okay, maybe they're good people. But as we've seen with national politics, what we all think of as a law turns out to sometimes be just a social convention. And if you have a different person in charge of that power, they can do different things with that power. And I'm here to tell you, you cannot be in a situation in a democracy where these companies are more powerful, because for the first time in human history, we have the ability at zero cost, at zero marginal cost to the company, we have the ability to influence you in a way that you don't even know you're being influenced. Because
So
of the
again,
news.
so again, the bottom line for you is it's just you're a consumer that's concerned. Is that what you're telling us?
Yes, this is my way of trying to make the world better. I know a lot of people don't think that, don't agree with me, but yes, at some point, you got to look around and say, what my dad used to say, Alistair, leave the world a better place. I'm just trying to do that. I was very fortunate in my life. And I do feel like at some point, you got to turn towards trying to figure out what kind of a world you're going to leave behind.
Laura, can I just take a few seconds to add a finer point to that? Because, you know, McTaggart was mortified when he met with the Google people and did the first initiative and felt that he had a solution when 2018 law passed, and was ecstatic about it. And then, you know, when we got into what the meat and potatoes were of legislating, and he saw how crappy it was, and I went to him and I turned to him and said, pal, this fight ain't over. You got to get back into it. I think it's just dropped. He just absolutely like, are you kidding me? How can you justify this, right? And we had these huge internal battles where I'm sitting there saying like, hey, pal, we want to get this right. We got to get it right. And we got to keep digging, and we got to be David and Goliath, and we got to keep handling this thing. Otherwise, it's going to get completely crushed, and all your effort's going to be worth nothing. So it was 2 phases. The first phase was there, and the second phase was like pulling teeth, and he got it, and the light went off, and we're in the war. And it's the right war to be in. And I think we're doing the right thing for 1,000 reasons. And I'm excited about it. And I really appreciate that McTaggart has stepped up to the plate in an honorable way and doing the homework. We've spent so much money hiring experts on every issue, you know, to try to really think this thing through in a brilliant way.
Thank you.
Thanks you guys for joining us. I appreciate taking the time today.
Thank you very much.
Appreciate it much.
Thank you.